substance and process. I would like to introduce Professor Leszek Buszynski from Strategic and Defense Studies Center in Australia to chair the session. Professor, you have the floor.
Thank you. Well, welcome to the final session. Is that better? Right. Now, this session has been structured a little differently. We'll have a presentation from Bob Beckman, who needs no introduction, and then we have the panelists here who have presented before. They also don't need introductions, and they will be asked to comment or give their own views on the COC, and then we will have a discussion, question and answer session, which will close not only this session but the conference. Now, just some remarks about the COC to begin with, to stimulate thought and discussion. About conflict prevention, conflict management, fisheries management, management of environmental issues, navigational safety, or whether you go further and talk about resolution and regime established is indeed pivotal to our discussions on the South China Sea. So, to begin with, I'll ask Bob to take the floor. Bob, you're on.
Thank you for the organizers for giving me the impossible job of discussing or proposing ideas for the so-called COC, or Code of Conduct. I'll be running through a presentation in 15 or 20 minutes that hopefully provokes some prospects for establishing a cooperative mechanism, potential areas for cooperation, and then potential cooperation zone. Code of Conduct, Unrealistic Expectations. It's not going to resolve the sovereignty disputes. Code of Conduct is not going to resolve any of these issues to any degree. Also, with respect to the disputed islands, it's probably unlikely that, again, there's no clear rules as to what you... I think it's unrealistic to expect agreement among the parties, especially those that occupy islands, that they're going to agree on what you can do and not do on the islands they occupy. Legally binding and dispute settlement, if you see the little handbook or the little handout which was given to every legally binding. The Law of the Sea Convention is legally binding and has a dispute settlement clause. Has that prevented states from ignoring their obligations and not complying with the dispute settlement provision? And you go through the history of ASEAN, you'll see that most of the major commitments by this ASEAN countries are in declarations which are technically not legally binding. When you make a legally binding treaty, it's when you're providing for the technical detail that was agreed to in a declaration. So what are the prospects? You may reach agreement if it does not. The Declaration of Conduct of 202 does not have a geographic scope. The same issues will make it difficult on a COC. Legally binding and dispute settlement clause, I think it's probably not going to have either. In fact, I'd be worried if it does, because that's a guarantee. Where I think it's useful is it can establish a cooperative mechanism by which the states surrounding the South China Sea can cooperate. Let me back up first. I'll say first, what's it likely to focus on? It'll repeat the same things that are already in the DOC, that are in most self-restraint. Hopefully a hotline or other procedures, or at least a mechanism for establishing a hotline or other procedures to address incidents. A framework for measures to minimize the risk of incidents at sea, but perhaps a framework for working that out be without prejudice. In fact, even entering negotiations ought to be clear that the fact we're entering into negotiations should be without prejudice. What does that mean? It simply means that we're not giving up anything. We're not recognize not giving up or changing our position in any way with respect to the sovereignty claims and the maritime claims. Legal basis for cooperation, I think if we're talking about several issues, we can define, and I think everybody agrees in the surrounding states, that the South China Sea is a semi-enclosed sea, and therefore there's a conservation and management of living resources, protection of the marine environment, and marine scientific research. I think if the code were to establish a framework for implementing that for the South China Sea, it would go a very long way to the ASEAN countries. My view again is that the states bordering the South China Sea should control any cooperative mechanism. That doesn't mean all ASEAN countries. That means the ASEAN countries that border the South China Sea. It would, again, they would have to agree on which states border. They border it in the south, the tuna. Singapore would be a question mark. They would have to decide that. Probably most of us look at South China Sea, we don't include the Gulf of Thailand, so it would not include Cambodia, Thailand, Myanmar, Laos. And I think it's important that the state, some issues on this today, clearly borders the South China Sea. How do you deal with it? All of the ASEAN countries have a one China policy. Possible solution, I started on South China Sea back at the workshops on managing potential conflicts in the mid-90s, when Chinese tied environment, and to a certain extent they could contribute on marine scientific research, so long as it didn't in any way change their positions on one China policy. There's what we see the bordering countries are, and you can see that it does include, this is a map from the South China Sea arbitration case, and they drew a line and it does not include Gulf of Thailand. Cooperation mechanism, again, I argue that ASEAN states that are controlling could invite other ASEAN member states to cooperate on particular issues. The debris from South China Sea into Gulf of Thailand, the main sources of plastic debris in the South China Sea are China, Indonesia, Philippines, Taiwan, and Thailand and Vietnam. So again, they could be the major states cooperating. 121.3 also says the states who has an interest in plastic pollution, they could cooperate with the states bordering the South China Sea to deal with plastic marine debris, just as an example. The lead states for project perhaps could be regular meetings of the states bordering. The chairman of the cooperative mechanism could be rotated among the states bordering. Areas for cooperation, part 3. Land-based marine pollution. 80% of the pollution in the marine environment comes from land-based activities. They could clearly cooperate with each other to deal with everything from plastics to fertilizers, pesticides, and so on. Their own rivers and with their own ships. And therefore it wouldn't in any way address any of the problems of overlapping maritime claims, because you'd only be dealing with your own shoreline. Pollution from ships is another one. Pollution from ships is the flag state and the port states. So you don't have port could head a project on ship source pollution to implement MARPOL Convention and other conventions. Again, wouldn't raise any issues of the sovereignty and maritime claims. Cooperation on fisheries, more difficult. But if you don't sustain, in the seas will exceed the amount of fish in the seas by weight. Or that for living resources, we're all going to be eating jellyfish rather than fish, because they will be the only things left in the oceans. So unless states take measures, a regional fishing management organization could be established on Malaysia to consider this, because that would give you the legal basis for sustainably managing your fisheries. And of course, China should also ratify the agreement. And fisheries. You could agree to coordinate your no-fishing zones. China declares a no-fishing zone, but it does it unilaterally. But if the states would all agree to a no-fishing zone and they'd all enforce it against their own vessels, it would not, again, raise the issues of sovereignty or maritime claims. You could all agree to bans against vessels flying your flag or owned by your nationals. You could also agree to establish marine protected areas where fishing is prohibited, without regard to who owns that area, because you all simply agree to prevent your fishing vessels from entering it and to punish them if they go there. So there's many areas where states could cooperate. It should be vessels not only flying your flag, but vessels under your jurisdiction and control, meaning vessels owned by your nationals or your companies. You need rules that Coast Guard, perhaps if you see a Coast Guard from vessel, country A doesn't go after it, but he reports the time and place and coordinates and vessel number to the flag state, and they take measures to enforce it. If trust were established, that would work without raising incidents at sea issues. Establishing a cooperation zone. This doesn't have to be under a cooperation mechanism. This could simply be an agreement. I stole this idea from the previous idea of the Philippines a few years ago of establishing a zone of peace, freedom, friendship, and cooperation. This is sort of the same idea. China, the Philippines, and Vietnam could establish a cooperation zone as a starting point in the northern part of the Spratlys, where many features are occupied by the three states. Areas rich in fisheries, it's rich in marine biodiversity, including coral reefs. Many of the features are occupied by those three states. And if you look at it closely at a map, you'll see some large reefs. There's actually 4 or 5 different islands occupied by 3 different countries. Again, it has to be without prejudice. The fact that you're cooperating doesn't mean you recognize the legitimacy of anybody else's claim or that you give up your own. It could be established first outside the areas claimed by Vietnam or by Malaysia and Brunei. That's just an idea. Taiwan does occupy one major feature in the same area, Ituaba or Taiping. But perhaps it should first be zone could be agreed between China, Vietnam, and Philippines, and they could simply invite Taiwan to cooperate. That's the area, that's an old U.S. map from 2010. All those features, those in red are occupied by, if you can see them, are occupied by China. Those in green are occupied by Philippines. Dark one right of the, sort of in the middle to the upper left is occupied by Taiwan. The orange ones are occupied on this map. It looks orange, it's Chinese. The purple ones are Vietnam. Now, a lot of these, it's the same reef with 5 or 6 or 7 occupied features, all very close to each other, all an incident waiting to happen. What I'm suggesting is you just take an area. It doesn't have to be this area. I just asked one of my staff to draw a map around some of the reefs. If you take an area, we could all agree that this is an area, it's rich in fisheries, it's rich in marine biodiversity, it's rich in coral reefs. Let's all agree not to go in there. Or let's all agree not to fish there. That's the actual occupation. Some of these are islands, some of them are potential islands, some of them are just rocks. That shows who occupies them, different colors, which means same large reef is sometimes 7 different features occupied, very, very close to each other. What would a cooperation zone be? Establish in an area that doesn't infringe the freedom of navigation of anybody. Because these areas on old maps are areas to be avoided. Why? Because there's coral reefs. You go through there, you're going to run aground. This shows you the major fishing lanes through the South China Sea. You look there, the reef, the area that I've identified is right in the middle where there is no major fishing lane, or no major sea lanes of any kind. Your commercial traffic is not going in there because it's too dangerous for commercial traffic to go in there. So you could create a protected area in a way that would not in any way infringe other states' rights to navigation. Exact location doesn't matter. It's more establish the principle and establish trust. may begin with 2 or 3 small zones. They begin with a zone just where only 2 countries occupy islands, and then try to expand it into more. Cooperation in the zone, the idea would be prohibit fishing by your vessels, engage in marine scientific research to try to figure out how to protect the marine environment, how to restore the coral reefs, etc. Protect vulnerable species, endangered species, and so on. Each state would again prohibit vessels flying its flag to prohibit the area, and take measures to ensure strictly that any vessel that violates it gets reported is punished under their law, so you're not having any problems of foreign countries interfering with your vessels. Since many of the islands in the area would be occupied, you could have an agreement that military vessels or supply ships of the COI claimants would have access to resupply people on the island. Claimants could agree not to enter the waters within a certain distance from any island occupied by another state, and you could develop a system to monitor traffic if everybody would agree to carry transponders. And vessels of non-claimant states or other states could be requested to comply with the principles in the protected area. Conclusions. I'm going to finish on time. It's very important that the COC, even the negotiations for a COC be without prejudice. You don't want somebody to come back later and say, well, you talked to us about this. That shows you recognize we have a legitimate claim. So you avoid that by making it completely without prejudice to your legal claims. States concerned, as well as the media, should not have unrealistic expectations about what the COC can do. Will not solve the disputes, won't solve the maritime or sovereignty disputes, but it certainly can help reduce tensions, establish trust, and build a framework for cooperation which would restore confidence and hopefully reduce tensions. So, thank you all very much.
Thank you. So what are we looking at? We're looking at an agreement which certain ASEAN countries would like to be legally binding, and if it is legally binding, it requires a dispute resolution mechanism. If it's not, then we're talking about a cooperative mechanism under Article 123 of UNCLOS, which may include certain cooperation zones. And we're looking at geographic scope. It has to be without prejudice to sovereignty and the sovereign claims. And it has to include, there has to be a decision, some agreement, some consensus on the kind of activities that will be included. Of course, navigation safety, marine pollution, fishing, all those will go in. People won't, there will be little opposition as regards, and little dissent as regards these issues. But what about the more troubling issues, such as the activities of coast guards, paramilitias, or naval vessels, or submarines, or American or US FONOPs, and so forth? And linked with that are other issues, that is the involvement of littoral countries, not members of ASEAN, since this is an ASEAN document, and also the relationship between this agreement and external powers. What kind of relationship can be envisaged, and that includes, of course, not only the US, Japan, but China as well. Well, we'll move to China, since China's role is indeed critical, as everyone recognizes. So let me ask Professor Renping Zhang to comment. Now, commentators will have around 8 minutes maximum to discuss these issues, content, activities, feasibility, everything that we regard as important for the implementation of the COC.
Oh, thank you, Professor Buszynski, and also my pleasure to have carefully listened to the excellent presentation by Professor Beckman. As a matter of fact, I do agree to Professor Beckman's presentation in principle. So. And I will finally comment on your last several points. Well, as a matter of fact, we have 25 years to start negotiation on the peace and the stability in the South China Sea. We started from 1992, and we had a very successful result in 22. And we started again the COC initiative in 2012. Then 2016, we got our initiative for the COC framework. In that case, this year, we have decided to have the COC framework and start the consultation and the negotiation on the draft COC text. The Code of Conduct in the South China Sea, or COC, is intended for the regional peace and stability in the South China Sea. The COC framework is agreed and adopted this May and confirmed at the China ASEAN Foreign Minister meeting in this August. The COC framework represents a crucial phased result in the entire COC negotiation progress, which has laid a solid foundation for the further negotiation. The early harvests of efforts include the queues for the Maritime Enforcement Agency, the hotlines between our senior diplomats, crisis management, measures at sea, and so on. Well, another thing is the areas of maritime cooperation. As we mentioned this morning time, that in this morning's session, that the area include the maritime search and rescue, the marine environmental protection, and China and ASEAN countries have made some progress and achievements on the basis for consultation and compromise. China ASEAN Summit announced in early November this year to start the consultation of the draft COC. That is the very brief background, as a matter of fact, if we can recall the historic background. Well, what is going to do? What are we going to do for the next step, or what is proposed from both sides, China and ASEAN? China and ASEAN countries need negotiation and consultation on the draft COC. That's for sure. The development of the draft COC should follow the ways that both China and ASEAN countries agree to pursue. The COC should include the right and the responsibility of all the parties concerned. China's position is proactive and positive in the COC legal binding, which is subject to the final consensus, while the DOC has no legal binding clause at all. While China is open to discuss anything with the ASEAN countries, no matter we like it or not, we will reach our common goal by consensus and compromise. China and ASEAN countries should make efforts for consultation on the draft COC and continue to constructively advance the negotiation towards the early conclusion of the COC. And also the China and the ASEAN countries endeavor through the consultation of the COC to enhance mutual understanding and trust, to build confidence, which is also mentioned in his Professor Beckman's presentation. Well, the final COC will make the stabilizer. I call it the stabilizer. I know some other official translation call it the anchor, because I'm from the shipping industry, this point of view, we call it stabilizer. Anchor doesn't move at all. Stabilizer keeps you stabilized. That's a slight difference, from the technical point of view. The final COC will make the stabilizer for the peace and the stability in the South China Sea. And we could imagine the future picture of the COC as China promotes the principle of the common destiny, not something different. When it comes to the comment to our Professor Beckman's presentation, I said, in principle, I agree to him. But there is one thing I need to slightly highlight, that for the involvement of all the regional players, including Taiwan, our bottom line, our policy is a one China policy. We may not use the term different from the Chinese government, the policy. Thank you.
Thank you. From China's perspective, what would the COC contain? Well, we'll discuss that later. Now, could I ask the panelists to keep their remarks very short, because we'll come back to you. We'll have several rounds of comments. So, Jay, about 3 minutes or so, please.
Okay. Just some quick reactions. I find Bob's proposal, of course, interesting. After all, it is based on ongoing discussions for quite some time now. Just some notes. I look at this from a slightly jaded perspective, having participated in the drafting of the original document that became the DOC back in early 2000s. And I remember clearly that the original document that we produced was about 4 pages with about 10 or 11 articles. And the sticking points were early on were basically the area of application, whether it should be explicit or not, the specification of activities to be cooperated on, the provision on ratification, which went into the nature of the document, and at the time the most important concern, which was to the issue on new occupation of unoccupied features. I find that these issues are probably going to be echoed again in the current discussions. So when Bob presented that proposed area, I was immediately thinking that's probably going to be debated at length, because whenever anyone tries to draw an area, immediately all the diplomats and lawyers and government personnel will immediately equate it with an area of jurisdiction, which means that it must have some kind of relation to whether or not you're actually conceding some part of your claim. And a without prejudice clause might be a good way to try to address that concern. But I think that based on the previous experience, even just identifying an area is going to be a bit too sensitive. On the activities, the key activities we need to address really are fishing and petroleum exploration. And although a lot of attention was given to fishing in connection with marine environmental protection, probably there's something to be, we need to discuss what to do with petroleum exploration, because as it is happening now, the Philippines cannot undertake any petroleum exploration in its area, apparently without Chinese consent, or unless it's under some kind of joint development agreement. And if that is what's going to take place, then I don't think it will be acceptable to any of the smaller littoral states. So that's going to be a problem, and we need to meet that head on. Nature of document, yes, it will always be there, but I think it's clear that it'll eventually end up to be a non-binding instrument. Now on the, but despite this, I think the idea of a code of conduct that is addressed based not on an idea of an area of application, but rather on who it will be applied to, meaning to citizens or vessels, and by the states through exercise of flag state jurisdiction, might be the best bet, because after all, you can't do anything in that area without being on board a ship or an aircraft, no? Unless you're really on the island. But then again, anything that happens on the island is probably going to be off limits to this discussion. So that's why I think I agree with the part where, like I said in my previous presentation, the idea of unilateral measures that actually benefit all, that might be the better starting point. And then my last point is on process. I think one of the problems with the COC discussions from the beginning, even the DOC, is that there seems to be this assumption that once you negotiate that you need to negotiate a document that comprehensively settles the issues that you agreed to, and that will generate trust and confidence, as if trust and confidence flows from the document. I think experience has shown that that's not how it works. And it's better to build trust, to earn trust among each other, basically, and build up that confidence through experience. So my suggestion is actually that to consider the possibility that the code of conduct will not be one document, one final document, which will take years, maybe another decade to negotiate, but rather a set of incremental agreements that progress over time, so that the code actually expands over time. You agree only to things that you definitely will be able to accept and implement, no? And then you keep working on additional agreements. I think that might be a process to consider, especially considering that there are some issues that are clearly much more urgent, no? Such as the environment, fish stocks, no? Militarization, etc. Those are very urgent because the issues are there and they're happening. If we could address that incrementally, even incrementally, one issue at a time, one issue per year maybe, I mean, that might already be a better measure of progress rather than another announcement that we will start discussing a topic next year without a specific date. No? It's like watching a radio serial. No? So actual substantial progress is probably better on things that are actually doable. And so that on the basis of that experience, then you incrementally build up the code. I think that's all I can say for now. Thank you.
Now, the Philippines has pushed for a legally binding code. And do you think that there should be a legally binding code? Or do you think that we should just speak in terms of a non-legally binding cooperative mechanism? We'll come to that. Now, let me ask Shafia Muhibad to comment. Now, she is from the Center for Strategic and International Studies in Jakarta, but currently in RSI, an institute in Singapore. And those of you who know Jakarta, the CSIS is perhaps the premier think tank in Indonesia, so we can expect something great from you in terms of articulating and expressing Indonesia's view of the COC.
Thank you, Chair. Indeed, I'm a little bit not too sure to what extent I can contribute to the discussion about the COC, but I guess I can discuss a little bit about, how Indonesia views it. I mean, if you follow from time to time statements, documents issued by officials in Indonesia, basically there are three lines of consistency. First is that it continues to insist that it is not a claimant state. Secondly, it insists that it seeks to play a facilitating role, or what they always say, the honest broker. And then thirdly, it continuously seeks to expedite the process of COC negotiations. In the latest statement, this was paraphrased as expedite the process of a post-COC framework negotiation. So I think that's particularly interesting. And with regards to this, the statements keep saying that it seeks China's commitment to a clear timeline for the earliest conclusion of the COC. If you look at most of the statements, one has the impression that the fulfillment of a COC is really something that is regarded as important by Indonesia, but you don't really find a thorough discussion on the really substantive parts of a COC itself. Earlier in April, relating to Bob's presentation about potential areas for cooperation, interestingly, back in April this year, there was an interview with President Joko Widodo, and he was asked about his views on the process of COC. And interestingly, he emphasized that states involved in South China Sea dispute should engage in concrete cooperation well before COC is developed. So he basically, his view is that all types of cooperation should be well pursued before any steps are taken towards a COC negotiation. He did mention, of course, fisheries is on top of his agenda for cooperation in the South China Sea. That is very understandable because of his prioritization on the fisheries industry in the country. So I wish I could find more on how Indonesia plans to develop any kind of cooperation with the other states bordering the South China Sea in this matter. But if you, again, if you look at most of the statements coming out from the Foreign Ministry, it really seems that the main goal is actually the COC itself and not really going into the details about what is in the COC. I guess that's all I can say for now. Maybe I can add a little bit more later on. Thank you.
Just a comment. Now, your previous president and your previous foreign minister, that was Martin Natalegawa, was actively involved in the formulation of the COC. Now you have a new president, Jokowi, and a new foreign minister, Retno Marsudi. So Indonesia seems to have lost interest. Anyway, we'll come back to that. Now we move to Malaysia and Captain Martin Sebastian. Everyone is familiar with Martin's comments, but you'll have some more of him now.
Thank you, Les. We have an ASEAN-China Joint Working Group, which is led by the Ministry of Foreign Affairs. We, as a policy think tank for the government, we provide advice to the Ministry of Foreign Affairs. One of the few advice that we have provided is that we need to look back at the tenets of confidence building, which is we need to go back to the DOC. The DOC has joint cooperative activities. Why is it having joint cooperative activities? It's for functional cooperation. Functional cooperation builds trust. Trust builds confidence, and then confidence can actually have contributing to preventive diplomacy. But then when we look back at the implementation of the DOC, paragraph 6, and we talk about marine scientific research, we talk about transnational organized crime, search and rescue, how far have we come? In 2012, there were 4 expert committees that were set up, which is marine scientific research, search and rescue, transnational organized crime, and all that. What is COC going to do to address these committees? How are these committees going to contribute to the COC? In what way? What kind of functional cooperation can come? I'm not into the legally binding and all that. I'm more into trust building. And when you talk about search and rescue, transnational organized crime, and all that cooperative arrangements, what about shepherds like UN? When you talk about Sustainable Development Goals 14, you talk about marine scientific research. How do you park under a shepherd? You talk about search and rescue. How do you park under ICAO and IMO? You talk about transnational organized crime. Where does UNODC come in? Where does World Customs Organization come in for smuggling in our containers and all that? How do they come in and be part of this mechanism to build confidence? So that's my question. Thank you.
Well, thank you. Now we, last but not least, we move to our organizer. And for comments relating to Vietnam, Dr. Chan Trong Thuy.
Thank you. I'm taking part in organization, but my comments is personal and not Vietnamese, not BAV or FES. First I would like to appreciate both presentation, very comprehensive, and I agree about 80% of the presentation, especially on the nature of COC. I agree that the COC is not for sovereignty resolution or dispute resolution, but it's more for management of disputes and promote cooperation in the South China Sea. The second issue I would like to address is, as Martin already mentioned, is a relationship between DOC and COC, or more broader, is a relationship between COC and other existing frameworks or agreements. According to DOC, we have Article 10 that the party will negotiate for final COC. So discussion and negotiation about COC is one way of implementation of DOC. But the question here is if we adopt a COC, incorporate own elements of DOC, so whether we should use both documents or not. That's a big issue. But if the COC incorporates some parts of the DOC, it's better to keep the both document in effect. The second issue is relationship between COC and other international law instruments. Some people concerned that some regional countries can localize the universal components or provision of international law to serve interests of local or regional countries. So my proposal is that it's better to put it in parallel so that the COC have to reflect or making it incompatible with existing universal international law instrument, especially the UN Convention on the Law of the Sea. Not only on a clear provision of UNCLOS we should respect or incorporate into COC, but also some ambiguous state provision of the UNCLOS, for example. Regional countries should not clarify or make adjustment according to their own interpretation. The third issue, I think here also the issue of geographic scope. Yeah, there was very difficulty in discussion during the original COC, during the one before the OC, about the geographic scope, whether it include paracel or whether it's just only limited to Spratly. So parties agree for ambiguous South China Sea. So I think in the COC it's better to keep the scope as a South China Sea, but it's difficult to clarify where is the South China Sea, of course. But here, geographic scope, people now mostly mention about the area of application on the land or disputed land feature and overlapping maritime zones or continental shelf. But one dimension, I think, like a focus is the air issue. We have a lot of maybe, right, or some different interpretation on the activity on the airs. Other issue is the role of third party or other stakeholders, because in the South China Sea, we witness not only activity of coastal states, but a lot of but other so-called stakeholders also have rights and obligations. So how we can manage or reconcile the opposing views on rights and obligation of coastal state and user states. And second issue is that the implication of the tribunal ruling. Now we have a high sea, a big pocket of high sea, right? So the high sea, that means open for everyone in the middle of South China Sea. So fishing boats from US, Japan, or Australia, in theory can have the rights to go fish there. So how we can manage the relationship between these activities? The final comments on this round, I think two most important components of the COC is self-restraints, or someone called do and don't activities, or prohibited or acceptable activities, right? That is main issues to prevent incident at sea. Incident at sea is one of the main reasons why people calling for COC. Without incidents, we don't need COC. Second component is cooperative activities on a lot of dimensions, fishing, environmental resources. But here, from my understanding is that two dimensions should go parallelly. And also, this is also in accordance with international law, especially article, as we discussed in the latest section on self-restraint in disputed or overlapping maritime zones and cooperative activity in disputed or maritime zones. So that's the first round.
Should it be legally binding? Vietnam has pushed for it in the past.
I'm not sure what is Vietnamese government position, but I think it's better for Southeast Asian countries for legally binding documents. But my personal opinion is that we need not only legally binding, but also substantive components of the code. If your COC with legally binding but with provision contain nothing, right? So it's not useful. What is useful here? We need legally binding but very substantive components or elements of the COC. It should go parallelly, not only focus on legally binding aspects.
Now, I'll ask the panelists again and to focus on a particular issue, and that is content. Preventing incidents at sea. Everyone agrees that that should be included, and the Code of Conduct should detail perhaps particular incidents that everyone should agree, should accept that should be prevented at least. Now, the difficulty here is that many of those incidents are created by or instigated by coast guards, fishing vessels, which are being coordinated by naval vessels behind the scene. So in which case, it makes little sense unless you include naval vessels as well, those that are in the vicinity. How do you come to grips with incidents at sea when incidents are being caused in this fashion? That's what I'd like to ask the panel. Now, for some elucidation of this point, let's turn to Professor Zhang Renping. Incidents at sea, right, and the activities of coast guards. Turn to you.
I agree with you, and I do understand your intention. As a matter of fact, that is really important. As we said, the incident at sea should be prevented by all means, no matter between the coast guards or maritime enforcement agencies or the fishing vessels, as well as the player behind the scene. Nevertheless, we all agreed in our comments, five commentators, that the self-restraint should be emphasized. We need to keep our self-restraint from several perspectives. One is the state level, the government. Two is strategically. And also we need to think about the sovereignty of each state. In that case, we have to keep calm at sea, and we have to follow the international conventions, the correct, we call it the rules of International Convention on the Prevention of Collision at Sea. So that is my point. Thank you.
And what about military activities? This came up in one of the ASEAN discussions on the Code of Conduct earlier this year. And the Chinese delegation made a distinction between offensive and defensive. American activities were naturally considered offensive. And what China was doing in the South China Sea in relation to the reefs that had been rebuilt was naturally defensive. Well, we can come back to that. Now, Jay. Incidents at sea, what should be included? Okay. I want panelists to focus on the content of the Code of Conduct. Okay. Too often we have vague statements, pious declarations, but we want to know what will be included, what will work.
Mm-hmm. Okay, on incidents at sea, my take on this is that, even based on studies, clearly one reason why incidents at sea have increased is because of the employment of coast guards in order to conduct these so-called sovereignty or sovereign rights exercises proactively against claimants. And one party has opened that program in 2007 and incrementally increased it, almost doubling it every year, and now we have this until we have this problem. So clearly, addressing incidents at sea should be one of the priority areas for discussion. To a large extent, I think incidents at sea can be addressed or prevented by emphasizing the need for all the littoral states to ensure good seamanship, compliance with the general practices and rules, and that will already go away towards avoiding this. So no crossing the bow, no intimidating maneuvers, no harassment, shadowing. I mean, just following good seamanship rules and practices should already contribute to lowering the possibility of this. Nonetheless, there will always be a need for mechanisms. So those mechanisms like hotlines between operational commanders, of course, will help. On military activities, well, admittedly, this will always be a problem. But I tend to think that in reality, the only real restraint on military activities seems to be reciprocity, action, reaction. And right now, what we're seeing, however, is that you have the two major powers, China and the US, basically acting and reacting vis-a-vis each other, not with less attention being given to the impact of those activities to the smaller states. I mean, I think that the Southeast Asian states first have to come to an agreement on this issue. They cannot dance around it, and just because these are two major powers, they really need to have a serious discussion and take a position that applies to both great powers, to all the powers with military activities, to set some kind of ground rules on what should or should not be done, what they see as potentially destabilizing or not. Whether it's offensive or defensive, it doesn't matter. As long as there's weaponry, you can always quibble about whether they're offensive or defensive. Even a defensive Coast Guard vessel that's 10, 20,000 tons clearly can be used for offensive purposes against the smaller Philippine ships, which are probably, less than 1,000. So I think that kind of discussion will really not move forward, that kind of distinction. It has to be either you have military activities of a certain nature or not. Now, perhaps there can be some distinctions as to the type, whether it's aerial or naval or on the islands. But really, this is something probably that right now the ASEAN states probably cannot immediately take a position, and they need to work it out among themselves first before they bring it to the COC discussions. Yeah.
Shafia, perhaps you can answer that question about Indonesia's interest, and what is Indonesia's attitude towards the idea of a legally binding document?
Back to your questions earlier, I suppose, comparing different presidents and different foreign ministers. That's correct. Different presidents, different priorities, different foreign ministers, so far different approach towards the South China Sea issue. Naturally, there can be the impression that is given that Indonesia now puts South China Sea issues, if not foreign policy issues as a whole, in a lower priority as compared to the previous president. But I can assure you that our foreign ministry would say otherwise, that it's still important for Indonesia. Sorry, what was your question just now? Legally binding. Oh, legally binding. Yes. My last conversations with several people from the foreign ministry, they claim will still want to pursue a legally binding code of conduct. But again, as was mentioned by another speaker just now, The concern is that it be legally binding without any substantial development from the existing DOC. Because the tendency is that if you're aiming for something, for example, for Indonesia, aiming for a COC that is legally binding, then the concern is there might be a neglect on the substantial requirements that that need to be fulfilled. But it's still, you talk to anyone at the foreign ministry, they say number one idea is to have a legally binding COC.
Now, Bob, we'll turn to you. You have the right to make some parting comments, since you had 80% agreement from one of our panelists here. It's quite high.
I think some of the speakers have mentioned points that I haven't dealt with in my presentation, such as do you maintain the status quo on existing features? Do we have provisions for no new occupation? I think some of these things would be boilerplate, the same provisions that are in the current DOC. The relationship with other instruments would have to be dealt with. I think some of the same provisions that are in the framework and in the DOC would be repeated in the COC. What I'm suggesting is that you create a framework for cooperation with clear obligations on meetings, chairmen over certain issues. What I have in mind, the Malaysians and Indonesians and Singaporeans may understand, I think the most successful cooperative arrangement in Southeast Asia is the Straits of Malacca and Singapore. It's because the three states are working together. They invite others on particular issues to help them, but they're in control and their sovereignty isn't compromised. I think you could apply some of those same principles to the South China Sea, having the states with a direct interest being the ones in control. And I think that's where I believe that there's a lot that can be done with respect to fisheries, with respect to pollution. Whether it's a status quo on an incidence at sea, again, a cooperative mechanism could create a committee to look at. You're not going to have the details set out in the COC, but you could establish a mechanism to address the issue of incidents at sea. I think you can't go beyond that, or you're going to negotiate for another 10 years.
So here's a lawyer who thinks that it doesn't have to be legally binding, right?
Doesn't have to be.
Shouldn't be legally binding. Now, Martin, could you focus on those issues I mentioned, military activities? You've dealt with NTSs, so-called non-traditional security issues, about which there's agreement. What about these more troubling issues?
I want to reiterate about the legally binding thing first. You just imagine the penal code of a country. You have a section, and then you have the punishment against the section. If you contravene that section, you're found guilty in the court of law under this section, then the punishment is so and so. Where do you want to put this punitive clause in a code if you want it to be legally binding? And how are you going to enforce that punitive action? You've got to think of that. We don't simply talk about legally binding and, how are you going to enforce and what kind of punishment you want to put, what level of punishment you want to talk about. And when you talk about incidents at sea, maritime incidents, miscalculation, spiraling conflict into, all kind of stuff that we talk about. These incidents will not escalate a strategic fallout, These are all logic issues that captains know. When you talk about law enforcement at sea, it's the same thing with the law enforcement on land. Your job is to bring the criminal to court and get the court of law to act on a crime. You don't shoot to kill somebody. You don't go and, fire at a boat and destroy it, You need to answer in the court of law because it is an encroachment. Then you enforce your jurisdiction, your laws on that person. So a humanitarian thing is there. You need to perform your functions as a law enforcement agency according to the perils of humanitarian law. So that is the principle when you talk about managing your maritime estate and enforcing and all that. And if it's a diplomatic issue, come back, make the report, take the evidence and make a diplomatic note and make a diplomatic protest. This must follow the conventions. So if these don't follow and you start talking about something that is so small that can escalate into a strategic, I think these are not logic conversations. Thank you.
Finally, Dr. Chan.
I would like to comment on the issue of incident at seas. From my own observation, we see three types of incident at sea in the South China Sea. First one regarding to navigation activities, right? That is relating to the issue that Jay mentioned. We need good seamanship so that to avoid incident regarding to navigation. And I don't think that is a difficult issue because if parties follow the international convention, queue and correct, right? So we can avoid the incident with navigation. Second type of incident is incident between user and coastal states regarding different interpretation of rights and obligations. We have some incident between the US and China regarding to military activity within EZ. Martin mentioned about the unlikely of escalation, but here we should worry about is relating to power struggle between the rising and established power. So small incident may be causing misunderstanding and it can escalate. The third type of incident is more complicated and concerning own coastal states and claimant states in the South China Seas. And I see also here two types of issues. First is regarding the incidents on enforcing claims on overlapping areas. That means the exclusive overlapping of exclusive economic zones and continental shelf generated from undisputed land features. Second one is the maritime zones. We call it, as we mentioned before, the disputed maritime zones generated from disputed islands or land features. And we can have a mix here of overlapping and disputed area when one party can use the disputed land to claim for overlapping maritime areas. So here it's more difficult for prevention incidents if party continue for enforcing their legal claims, right? Because it's relating to sovereignty rights and jurisdiction enforcement in this area. So I think here we have also players quite complicated. The government can control or manage governmental vessels or aircraft, but how we manage the activity of non-governmental vessels, fishermen or paramilitary or militias activity in complicated jurisdictional maritime areas. So here my conclusion is I'm quite skeptical about any COC can prevent incidents in the South China Sea, because very, very complicated issue here regarding the rights, obligation, scope of activities, especially scope of application. Party cannot agree where's disputed area, where's overlapping area, and the rights and jurisdiction and between coastal state and user states they continue for more than 100 years.
Now, you're skeptical and pessimistic about the prospects for COC in handling these issues, and what's the point of moving ahead?
I think if we're moving ahead, we can prevent some kind of incidents, but not all. For example, as I mentioned, incident relating to navigation, or between user state and coastal state, maybe between China and US, they can reach some kind of understanding, or between parties with overlapping, with clearly and legally overlapping maritime zones, between Vietnam and Indonesia, for example, or between I don't know, Malaysia and Philippines without Sabah, right? So you can manage the incident in the overlapping EZ and continental shelf. But on the other areas is more complicated.
So you see it, as you see it, it can be partially successful. Okay, now the panel has identified the issues for you. We've had some discussion here, and this is all to the purpose of stimulating questions and a discussion within the audience. Now, we have about half an hour left for the questions and the answers. So who would like to start? We have a question over there.
Thank you, Professor. Well, I have followed with keen interest the presentation and also the discussions among and from the commentators, which are quite interesting and I would say fascinating. Well, of course, to me personally speaking, regardless of form, a COC is well expected to provide a set of norms in conformity with the existing international law that guide the conduct of states in the South China Sea. And also in this regard, commentators have pointed out quite a number of important issues or points. So I just want to pick up 2 points. One is about self-restraint, and also the other point is about the prevention of incident at sea. So concerning the self-restraint obligation, so I would like the commentators and the panelists to further go into details. What should be there in order to, how can I say, to realize the obligation of self-restraint. And concerning the prevention of incident at seas, I also would like the panelists to focus on well, standard operations procedure, or what should be there in order to, how can I say, to prevent the any possible incidents at sea in the South China Sea. Of course, I know that Dr. Thuy did mention somehow, but I would like to see the panel to go further into specific or into details. Thank you.
So you would like the panelists to address the issue of content,
yeah,
procedures for handling incidents at sea, right? Well, let's start with Professor Zhang.
All right, thank you. Thank you again for the good question from our colleague of the Vietnamese. The first one is about the self-restraint. As I briefly touched upon earlier, that we have different levels of self-restraint. The priority is the state level. All the government concerned should take the precautions for this. And their relevant ministries or officials, even including the local government, we call it provincial officials, should be briefed with all the precautions prepared between or among those countries concerned. Another level is about the operation. As a matter of fact, we heard about Dr. Thuy's proposal or suggestion of the possible, the prevention of like a fisherman. This is a sort of a difficult one, or most difficult one. The operation level, we need to think about the routine training and routine operations procedures. I have a very good example that our Navy, that's a Navy, encountered years ago with a pirate at sea in certain area of another Indian Ocean, that we have to follow our Navy rules by reporting back or superior, then another superior level, That is the operation level. While another navy of another nationality, they have a different procedures because they don't need to report back to their home headquarters. They got instruction that the captain or the commander officer of the warship can give order to destroy the pirate. So that's the difference. In that case, from operation level for the maritime law enforcement agencies, we need to have a kind of a routine operation procedures. This information should be exchanged between or among our two law enforcement agencies instead of just one. For the prevention of incident, you need detailed examples. I mean, we had provided very excellent examples already. One is the procedures of like a good seamanship. And from international conventions point of view, we have the COREX. That is good, very good example. And the seamanship should be trained at the very basic maritime education and training, including those, the Maritime Enforcement Agency crew or officers. And the fisherman is rather different. And the most difficult one, even in our case, we can't give them correct instruction and correct time and in the right place. So that is the most difficult one. But we need to put our efforts for the fishermen's training to understand better for the behavior, even in areas what we call the high seas. Thank you, sir.
Martin, what should go in the document to deal with this issue? Self-restraint? Provisions to deal with
yes, that is
incidents at sea?
Self-restraint. There's a difference between law enforcement and military operations. Military operations, when they discharge their payload, they come under the principles of the rules of engagement. That means you throw stone, I throw stone at you. Okay, you fire, I fire. Engagement, proportionality. But in law enforcement, it's a rule of application of force. You don't talk about engagement in law enforcement because you don't engage. Your job is to enforce the law. You don't go and engage the so-called criminal. That's the court to do it, not you. Okay, so self-restraint in a law enforcement issue, you need to be well trained to handle a criminal that is conducting a crime. So let's give you two scenarios. One scenario is Coast Guard and Coast Guard have to work together because therefore a common criminal is passing through, human trafficking vessel or transshipment vessel. That is, you need to work together, right? At the same time, you have a fishing vessel of another country, of another interest, and then you also need to report on that. So as a law enforcement officer on board that ship, you need to get proper evidence of that crime and report it back. So in ASEAN, we have the Mutual Legal Assistance Treaty. So perhaps something like that we could add into the code of conduct, where if a crime is committed by somebody from your country and is enough evidence by our law enforcement agency, then they should be prosecuted in your country. Those kind of stuff. So land and sea, there's no difference. If you're enforcing something on land, the same parameters, you do the same thing at sea. That's what I'm saying. So you're talking about incidents at sea and all that. Typical navigation. You're a captain of a ship. You're responsible for your ship crew and your cargo. So you take all the precautionary measures to ensure that they are safe. And if in the action of going to enforce the jurisdiction of your country in that estate, you have to do something. Don't be too excited. Make sure you take all the precautions. You're not at war. You're just a law enforcement officer. If you can't do it, come back, get your evidence and report it. Let your diplomacy and your country do all the other stuff. You are just an agency, a security agency. So Those are the things that is what is in reality when you talk about law enforcement and military operations. Thank you.
Thank you. A response from Bob Beckman.
Yeah, I think one of the things the COC could do, for example, on incidents would be have a procedure whereby, it's the same way with vessels following safety regulations or pollution regulations, you generally cannot interfere with a foreign vessel. So you report it to the flag state, and that flag state's required to report back to you. You could build something in the COC that when one country finds a vessel of another country, whether it's a law enforcement vessel or a fishing vessel, not complying with the rules that are agreed, you make a complaint and that state has to report back. In terms of self-restraint, you have a principle now of self-restraint in the DOC, but many states have not complied with that because, again, there's no procedure whereby if you believe your neighbor is not exercising self-restraint but is jeopardizing the situation, that some kind of process is triggered where it's investigated, right? That's what you have to build in some procedural mechanisms.
Jay.
I think with respect to self-restraint, we also need to be careful. We need to keep in mind that self-restraint means different things at different times. When the original document, the 1992 ASEAN Declaration of South China Sea came out, self-restraint there was in relation to self-restraint in international law with respect to the use of force, because the context of the 92 Declaration was the 1988 incident really between China and Vietnam, and the fear that force would become the norm for enforcing claims. So it took 4 years to do that. When the DOC came out, for the negotiations for the DOC, the idea of self-restraint was drew from the 1992 declaration, but in connection with the incident in Mischief Reef. So their self-restraint was in the sense of the claimants unilaterally taking action to expand their respective claims. And then in the years afterwards, in the course of these discussions of COC, etc., self-restraint clearly has moved on to self-restraint in the sense of claimant states should not take advantage of opportunities or incidents to further advance their claim. So it's really expanding in scope. Such that now when you talk about self-restraint, I think when in the COC discussions, it's much more broad. That being said, if you put in too much detail on the COC, that might actually be restrictive in a way, because you're going to have discussions on this. What do we have for Coast Guards? What do we have for law enforcement? What do we have for military? And that's just going to extend discussions. No? So maybe there should be some sense of propriety or relevance really to the topic. No? That is being discussed and to which self-restraint is being suggested.
Shafia, any comments? Any comments? Dr. Zhang.
Yeah, I think self-restraint relating to two kinds of activities. First one is activity to enforce claims, right? Or enforce the rights, and second one is rights protection. So when you enforce the rights to exploitation, for example, or activity on islands, on unoccupied or occupied islands, that's one set of self-restraint. What activity are acceptable, what activity are unacceptable. The second kind of self-restraint is self-restraint from other parties to prevent the first one from enforcing the rights, so-called rights protection, right? In that, we should have rule of engagement, but I agree that with the Coast Guard it's more difficult for rule engagement, but Navy should not use for law enforcement, for example, it can escalate the situation. But here, I back to the Martin comments about self-restraint from rights protection parties. We should use a hotline or diplomatic channel of interaction or communication rather than using vessels for ramming, for demonstrating forces on the sea, because it could not manage the incident, and it makes situation more complicated, and it can cause action-reaction cycles. Yeah.
Well, yes, we kept you waiting there, but finally we can get to you. That's you and Graham.
Thank you. My question concerns the composition of the parties to a code of conduct. I was struck that few of the participants gave much emphasis to the role of ASEAN in the process, but the DOC, and up until now, the COC process has been understood to have been one between ASEAN on one side and China on the other, although China's position is that it's in a bilateral negotiation or talk with 10 separate countries within ASEAN. But if we're going to apply a geographical definition of the South China Sea on a restrictive basis that it excludes the Gulf of Thailand and applies to the littoral states, and there's been already some consideration of whether Taiwan should be included in some shape or form, is it time to consider the question of whether the COC negotiation should be decoupled from ASEAN, and the geographical case could be applied to several members? Laos is obvious in being landlocked. Myanmar has only frontage on the Indian Ocean. More controversially perhaps, but Thailand and Cambodia are both within the Gulf of Thailand. So we could, in essence, end up with 6 ASEAN littoral states, plus China. I would be interested in the panelists' view on that.
To whom is that question addressed? To
all panelists who wish to respond.
I was not in any way suggesting that ASEAN centrality should be compromised. I think the COC should be between ASEAN and China. But under the COC, you could create cooperation mechanisms that are controlled by the states that border. And it's a very big difference. But I think that there's no way ASEAN countries would agree that this should be broken up and negotiated a different way.
Shafia, I can imagine how Indonesia would react to that proposal. Have you got something to say?
Yeah, seconding Bob, definitely a no-go for Indonesian point of view. That's just way outside of our usual, trying to be consistent with our policy with regards to the South China Sea. And ASEAN is currently our only option. If you may recall, there are various calls for Indonesia to play a greater role in the South China Sea, but up until now, it still sticks to its consistent position to do everything through ASEAN, and I don't think any alternative to that would be, would be something entertained by a country like Indonesia.
Yeah. I'm in favor of giving a greater role in the decision-making over the negotiations to the claimant states directly affected, similar to Bob's position. Because clearly, when you think about the original idea of the COC, this was created under very different circumstances when there were only a few ASEAN members, basically the original 5 and Vietnam at the time, and there were just new members coming in, so they did not have an active role in the reaching of consensus on those documents. The same with the 2002 DOC that was taking place, with the key states being the key leaders of the discussion. Primarily Philippines and Vietnam, actually, the exchange of documents for the DOC. Now we're seeing that we're seeing the disadvantage of having the non-parties basically becoming an instrument to derail the reaching of consensus. But I also think that we shouldn't be sacrificing ASEAN centrality for that, but because I think that there is also a means to create an internal process within ASEAN members that would allow that to happen. I mean, we've already seen there are several cooperation agreements between ASEAN members, but that do not involve the whole ASEAN, which seem to have been working. So like there's Malaysia, Philippines on a transboundary marine environmental protected area in Sulu Sea. You have the trilateral cooperation arrangement now. You have the Straits of Malacca and Singapore arrangement, and those are taking place even though they are all ASEAN members, and it's not it doesn't really detract from ASEAN centrality. So I guess a similar concept and process could be worked out before ASEAN actually goes to the negotiating table. Yeah.
So this is not the complete decoupling of the COC from ASEAN. It's a situation where the ASEAN claimants take the lead and are actively involved and under the ASEAN label.
I agree with Jay.
I agree with other ASEAN colleagues. I think we should not decouple COC discussion with ASEAN, but we should decouple COC negotiation with COC implementations. Because the COC discussion, as I mentioned earlier, that is one step of DOC implementation, and DOC involving all ASEAN members. But more important is that the South China Sea issue is not only the issue of coastal states or disputed countries or claimants, but also relating to the issue of peace, security, development, respecting of international law, freedom of navigation over flight. So that is regional issue. So regional issue require regional approach. And for ASEAN, that ASEAN role is ASEAN function and the COC discussion go parallelly, because COC discussion is not for resolution but for management of issue. So in that aspect, ASEAN can help. And by involving all ASEAN claimants country or coastal country can promote ASEAN role in regional security issues, promoting ASEAN consensus and centrality role. Without that, I don't think ASEAN can keep centrality role. But here we should separate with implementation. I agree with Professor Beckman mentioned point about when we talk about specific implementative activities, for example, cooperation, incident at sea prevention or management, that is involving parties directly concerned. But here one difficult issue is the form of negotiation, whether that is issue between ASEAN and China, or that is issue of 11 parties, or that is issue of 10+1. That is parties they have different interpretation. But I think to some extent, some claimants of ASEAN so far leverage the ASEAN for collective bargaining. But now China, to some extent, quite know how to use the issue of differences within ASEAN. So we have a more big issue here, and some non-claimants country can use the process for leveraging for national interest. That is also an issue.
We have a question over there. Yes.
Thank you, Mr. Chairman. David Ong from Nottingham Trent University. Just a question to the panel in terms of coordination of COC negotiations and the eventual adoption of that agreement with ongoing developments, which I tried to outline in haste in my presentation, which seem to me to be in some areas of maritime cooperation within the region quite extensive, especially with Track 2 then feeding back into Track 1, notably on environmental issues, maritime security issues. There might well be overlap. Sorry, I seem to be always talking about overlaps. But there might be overlap between those ongoing developments and the COC negotiations. Is there scope for a sort of coordinating mechanism between the COC and or coordinating provisions even between the COC and other ongoing cooperative developments? Thank you.
Is that question addressed to anyone in particular?
No, to
no,
anyone in the panel. Yeah.
The Center for Humanitarian Dialogue has conducted a few workshops one of the workshop was to implement the cures. So they came to us and they asked, how do we do this? So I brought them to a simulation center where each cubicle is a ship, and we have that back home in Kuala Lumpur. We brought in ASEAN Coast Guards, we brought in some navies, and we did the simulation exercise there, and we proved that queues cannot be used for Coast Guards, because queues is a military mechanism, because it uses alphanumerics, and Coast Guards do not need to speak English among their own Coast Guards. So that those are complementary measures that can support other regional mechanisms. So foundations, research institutions, or any other organization can complement the efforts, but we need a framework. And then we work along the framework, we report back, we have meetings, and then we see which is applicable and which is not applicable. I think that is already existing. Thank you.
20-second response from Bob here.
I think certain issues that are ASEAN and China should be dealt with under the COC. There are other issues of maritime security, transport of WMD, terrorism, where other states, freedom of navigation, where other states have an interest as well. So it can't be left simply to COC.
My initial reaction is that I suspect that the COC discussions will basically be self-contained, not because of it's deliberately, but because it inevitably has to be, because ASEAN has over 1,500 meetings a year, and there are so many of those mechanisms and frameworks that they have to coordinate with. They'll probably not be able to deal with those issues until they actually have a document that is more or less substantial. So maybe later there will be some room for how to do it, but that's already in the course of implementation.
Final word from our esteemed host and organizer.
I think one more issue here is that I agree with Professor Beckman mentioned about we should have realistic view about the COC negotiation process. So it may take more than 10 South China Sea Conference for finalization of the COC. But one issue here is how parties should conduct or agree with activities pending the finalization of the COC. That's a very important one. So DOC implementation and COC negotiation should go parallelly, but early harvest measure maybe should consider, and also incorporate on other issue of respecting or implementing international law aspect.
Well, that brings us to an end, just slightly after 5 o'clock. I think our time management has been excellent in this session, and it only remains for me to thank the audience, everyone here for their attention, and let's thank the presenter and the panelists in the usual way.
Thank you, the panelists, for keeping the time. And we're coming to very close to the end, and I would like to invite you to remain seated. Of course, seatbelt not fastened. Okay. Then I would like to invite to the stage Ambassador Nguyễn Đức Hùng from the Foundation for Asia Studies, Professor Nguyễn Vũ Tùng, President of the DAV, and Professor Lê Minh Tâm, Vice President of the Vietnamese Lawyer Association, to the stage for the closing session. In the closing session, we have Ambassador Nguyễn Đức Hùng, who will be the chairperson.